So again, yeah, my name is Mark Koerner, and I'm going to be talking a bit about the FMLA and ADA today, with a little focus in the FMLA on some mental health regulations that have been issued in a fact sheet by the Department of Labor in May of 2022. A lot of this is going to be a refresher for many of you, but to the extent that you have questions or it's not a refresher, feel free to reach out to me or anybody in our labor and employment team. So we'll start with the FMLA. The statutory purpose of the FMLA, there are four that are set forth within the statute itself, but basically the FMLA, or the Family and Medical Leave Act, is to balance the demands of the workplace and the needs of the family by providing a method where people can take time off from work to take care of their own serious health conditions, or to provide or for adoptions, the birth of a child, or to care for the child or their spouse. Essentially to allow equal opportunity, employment opportunities for men and women, while allowing them to care for themselves and their families. A little bit about FMLA eligibility. The first question that should be asked is really whether or not the employer is a covered employer. For a covered employer, it's a private sector employers with 50 or more employees that have worked 20 or more hours work weeks in the current preceding calendar year. All public agencies are covered employers, and private elementary and secondary schools are also covered employers. So once you've determined whether or not you're a covered employer, the next question becomes whether or not your employees are eligible to receive FMLA leave. Eligible employees must have worked for at least 12 months. They must have worked for 1,250 hours within the preceding 12-month period. They must be employed at a work site where there are at least 50 or more employees are employed within a 75-mile radius. That meaning if you have multiple work site locations and you have 25 in Lansing and 25 in Clinton County, you would be classified as having 50 or more workers. And eligibility for leave is determined as of the date the leave is set to begin. If you're a covered employer and your employees are eligible to receive FMLA leave, they're provided for 12 weeks of unpaid leave in any 12-month period. For service member caregivers, that is increased to 26 weeks in any month, a 12-month period. Leave is for a serious medical condition and may be taken in blocks or as intermittent leave. And the interesting thing about the 12-month period is you, as an employer, have a choice as to how it is that you're going to set that 12-month period. It can be one, the calendar year. It can be two, any fixed month or leave year. For instance, you could base it upon the fiscal year if you want. It could be the 12-month period measured forward from the dates of the employee's first FMLA leave, the looking ahead period, or a rolling 12-month period, which is used by a lot of employers. And the rolling is basically a look back method. So each time an employee takes FMLA leave, the remaining leave entitlement would be any balance of the 12 weeks, which has not been used during the period of the immediately preceding 12 months for the employee. So again, that fourth one, the rolling 12-month period, is a look back from the time that the leave is requested. Leave is available for birth, adoption, or placement of a child in foster care, serious health condition affecting an employee or the employee's child's spouse, parent. Again, it can be intermittent. It doesn't have to be taken in a full 12-week block. It can be a qualified exigency related to the service of a spouse, parent, or son in the National Guard services or on active duty. And service member caregiver leave for a spouse, parent, son, daughter, or next of kin. So while on leave, when an employee is taking this FMLA leave, they're entitled to return to the same position and pay that they were at when they began their leave, or they're entitled to return to a position of equal responsibilities and pay. In addition, while they're on FMLA leave, they're entitled to continue their health insurance benefits. And when they return, they're entitled to resume any other benefits that they had at the same level as when they as when they began their leave. So a lot of times the questions come to what qualifies as a serious health condition for an employee. So serious health condition includes inpatient care. So if someone's being treated in a hospital or other medical facility, or if they have continuing treatment, which continuing treatment means 3 consecutive days of treatment plus subsequent treatment for a period of time after that 3 days of consecutive treatment that relates to the same condition. So treatment of 2 or more times for the injury or illness by a healthcare professional, and treatment at least one occasion that results in a regimen of continuous treatment under the supervision of a healthcare provider, all related to that same specific illness or injury that required the leave. Specifically, conditions, pregnancy or for prenatal care, chronic serious health conditions that require periodic visits for treatment that continue over an extended period of time and could result in episodes of incapacity rather than a continuing illness, obviously asthma, diabetes, epilepsy, those types of things. A period of incapacity that's permanent or long-term, which treatment may not be effective, and any period of absence due to receive multiple treatments for restorative surgery or a serious medical condition. And as I spoke earlier, in May of 2022, the U.S. Department of Labor issued fact sheet number 208, which clarified the FMLA as it relates to mental health conditions. Under that fact sheet, the Department of Labor said that mental health conditions are considered serious health conditions under the FMLA if they require either inpatient care or continuing treatment. As with other serious health conditions, a serious mental health condition that requires inpatient care includes an overnight stay in a hospital or other medical care facility, such as a treatment center for addiction or eating disorders. A serious mental health condition that requires continuing care, like the other serious health conditions, is a condition that incapacitates an individual for more than 3 consecutive days, and then again ultimately requires ongoing treatment and multiple follow-ups for that same particular condition. The fact sheet specifies that chronic conditions like anxiety, depression, or dissociative disorders, those qualify as serious mental health conditions and would entitle an employee to intermittent leave to dealing with those particular conditions if they require treatment for those conditions for at least twice a year. We're going to talk about certifications in just a minute here, but even with the mental health conditions, an employee may require a certification of the need for the FMLA leave from a healthcare provider, from the employee. In addition to caring for oneself with a mental condition, the FMLA leave in the fact sheet says that an employee can take time off to provide care to family members with mental health conditions. And that care includes providing psychological comfort and reassurance that would be beneficial to a person who's dealing with a serious mental health condition. It's generally limited to a child under the years of 18 years of age, but may be extended to an adult that's suffering from a serious mental health condition if that adult is not able to take care of themselves because of that because of that mental or a physical disability. The fact sheet also talks about the facts that the military service member caregiver is entitled to 26 work weeks of time under the FMLA to care for a covered service member with serious mental health conditions. It's available to a current service member that's active duty that's suffering from a serious mental health condition, or one that is whatever the serious mental health condition is aggravated in the line of duty. So, for instance, if a service member was suffering from PTSD, an employee would be entitled to take up to 26 work weeks of FMLA leave to provide care to that service member and taking them to appointments, doing other things. So it also applies to service members suffering from serious mental health conditions. So FMLA leave, unlike the leave the earned sick leave that Tony was talking about earlier, is unpaid leave. So you're not required to pay the employee while they're out on FMLA leave. You can, as an employer, require that the employee run their FMLA leave concurrent with any sick time and or vacation time that they have. You can also make them run it concurrent with workers' compensation. Ultimately, when you're having them run the sick time or vacation concurrent with FMLA leave, it's a substitute for the unpaid leave. So you can have them use a portion, some or all of their sick time while they are out on FMLA leave. You're required, however, if you choose to do that, to advise the employee that they must run their sick time and or vacation time concurrent with their FMLA leave. So if an employee requests FMLA leave for a serious health condition, you can request a certification from that employee's healthcare provider. The certification, there's forms out on the web from the Department of Labor that require them to identify the serious health condition of the employee or to give care to a family member, and gives a qualifying exigency. They're required to give you the certification within 15 days of a request, unless there's a reasonable excuse. In the event that you receive a certification and you need clarification, which we'll discuss in just a minute, they're required to provide that to you within 7 days. You can request recertifications. We'll talk about those as well in a minute, but no more than 30 days, every 30 days, but there are exceptions. And ultimately, a fitness for duty certification can be used to make sure that an employee is capable of doing the job and is certified fit for duty before they return to work. So if you request a certification and you receive an incomplete certification, well, backing up first, if you receive a complete certification, you should not do anything. You should not request additional information from the healthcare provider. If you receive insufficient information or incomplete information on the certification, you can request in writing for additional information. As I said in the previous slide, you're required to give the employee 7 days to cure an incomplete or insufficient certification. And if that incomplete or insufficient certification is not cured, you are able to deny the FMLA leave. In the event that you disagree with what's contained in the certification, you may, as the employer, at your own expense, obtain a second opinion with respect to the original healthcare certification. And once you've done that, if you just choose to do that, and the opinions of the healthcare providers differ, meaning that the second differs from the first, then the employer may request, again, at the employer's option, a third opinion, which is ultimately the end all be all as with respect to whether or not the certification is accurate. There are circumstances, we recommend generally not to do this, but there are circumstances that you can contact a healthcare provider to authenticate and clarify a certification that you've obtained for an employee who's requesting FMLA leave. The authentication is essentially just to say, is this your signature and this is accurate? In that case, you don't need authorization from the employee. If you're requesting to clarify information within the certification, you contact the healthcare provider, you will need a specific healthcare release of information from the employee before you can make that contact. The contact with the employee healthcare provider should never be done through that employee's direct supervisor. It should be done through an HR professional within your agency, your leave administrator, or some other management official to make that contact. So while an employee is on FMLA leave, as I said earlier, you've got to continue the health insurance benefits under the same terms and conditions while they were not on FMLA leave, and the accrual of seniority and other benefits are not required while on FMLA leave, but they begin again once the employee returns from that leave at the same level where they left off. Whatever portion of the health care premiums that you were paying before the employee took FMLA leave must continue, but the employee is required, even if while they're on unpaid leave, to pay their portion of the health care premiums. You can cancel the healthcare insurance for the employee if the employee is 30 days late on their portion of the healthcare premium, if they fail to return from leave at the time that they were supposed to return from leave, or if the employee would have otherwise been terminated. For instance, if there's a reduction in force within your organization, then you also may be able to cancel the health insurance for that employee. So the employee is required to provide you with at least 30 days advance notification of the request for FMLA leave if leave is foreseeable. And if it's not foreseeable, obviously, if it's something that happens that comes without warning to the employee, then they're to provide you with notice as soon as practical. It's practicable for the employee to provide notice within the time required by the employee's usual and customary notice requirements, but individual circumstances must be taken into consideration. So in the event that an employee is hospitalized for a 3-day period and is unable to advise you that they're requesting FMLA leave, then you have to take those facts into consideration as with respect to the notice requirements under the FMLA. If you have call-in procedures, it is possible for you to discipline an employee if they do not comply with those particular call-in procedures. And calling in sick without providing more information isn't sufficient to trigger a request for FMLA protections. You're required to inquire further if you need additional information from the employee. So it's your responsibility as the employer to make that request on employee notifications. And again, that was a quick rundown through the the Family and Medical Leave Act. Another issue that employers are dealing with is Americans with Disabilities Act. Americans with Disabilities Act applies to employers that have 15 or more employees, and it prohibits discrimination against a qualified individual with a disability. Disability is defined under the law as a physical or mental impairment that substantially limits one or more major life activities. It has to be a substantial limitation. So such as a mild allergy to pollen or something isn't considered substantial and wouldn't qualify as a disability. It applies to people that have a record of impairment, such as visible scars. And it applies to people that have a perception of impairment. And what they mean by perception of impairment is that there are certain individuals that may have conditions which don't rise to the level of what would be considered a disability, but if they're perceived to have a disability by an employer and then discriminated against as a result of that perceived disability, it would be a violation of the ADA. And one of the other, as we talked about, with the mental health conditions, it does include a physical or mental impairment and any physiological disorder or condition affecting the neurological or musculoskeletal body systems. And that's again from the Code of Federal Regulations. So under the ADA, it has to be a substantial limitation to a major life activity. And the law is clarified that major life activities include, and obviously we qualify this with not limited to seeing, hearing, speaking, walking, breathing, performing manual tasks, learning, taking care of yourself, and even working. Minor non-chronic conditions of short duration, sprains, broken limb, they would not qualify or be covered under the ADA. So if an employee has a substantial limitation to a major life activity, then that employee can request a reasonable accommodation. A reasonable accommodation is something you do as an employer to make it so that this employee can still work within your organization, even though this employee has this disability. There aren't any magic words when an employee is requesting an accommodation. Essentially, if the employee, they don't have to say anything specifically. If the employee puts an employer on reasonable notice that they need an accommodation to do their job as a result of a disability, then you have to participate in a process to determine whether or not a reasonable accommodation would be suitable for your employee. And a reasonable accommodation can amount to many different things. changing your facilities to make it so they're more readily accessible to people with disabilities. Obviously, there are requirements under the ADA for buildings with ramps and that sort of thing. But if you can make it easier for your employee with the disability to get around or get to their workstation, that would be a reasonable accommodation. Job restructuring, modifying work schedules, reassigning that employee to a different vacant position would also be considered a reasonable accommodation for a person with a disability. Or acquiring or modified equipment and devices within your facility to make it so that an employee with a disability is able to complete their job and not be hampered by their disability. And that includes obviously training materials, policies, and providing readers or other interpreters. So if an employee requests a reasonable accommodation, the employer is required to provide that accommodation unless that reasonable accommodation that is requested would propose an undue hardship on the employer. It's defined as an action requiring significant difficulty or expense when considered in the light of a number of factors. In determining whether or not the accommodation request would create an undue hardship, you look at things like the nature and cost of the accommodation that's needed, the overall financial resources of the facility and the facilities involved in the provision of the reasonable accommodation, the number of employees that are employed at that facility, the effect that the accommodation would have on the resources or other impact that it would have on the operations of the business. You have to look at the type of the operation or business, including the composition, structure, functions of the workforce of that particular business. So there's a lot of different factors that you need to look into whether or not a reasonable accommodation would cause an undue hardship within the entity. Once there's been a request for a reasonable accommodation, you also have to go through this interactive process of determining of whether or not the reasonable or accommodation is acceptable. It's determined on a case-by-case basis, but essentially the interactive process consists of understanding that there's been a request. Again, no magic words are required to show that a request for accommodation has been made. You have to gather information regarding what the accommodation is, what the disability is. Then you explore the accommodation as per the employee's request and see if it would cause an undue hardship on the organization. One of the issues that is problematic or a common misstep in this interactive process is that when the person involved in the interactive process isn't properly trained on what they need to look at. Two, if they're really resistant to the idea of giving an accommodation, that causes a problem in the process. Complicating the process. A lot of times, if there's an employee that's requesting an accommodation, you don't have to give them the specific accommodation that they're requesting, but there may be a quick fix that doesn't require undue hardship within your agency. So being resistant to that change or complicating the process is also an issue. Showing or requesting too much information concerning a disability can cause an issue as well. So the interactive process is required under the law once request for accommodation has been made. And again, you have to make a determination of whether or not this request for accommodation or any accommodation is available that doesn't cause an undue hardship on a case-by-case basis on that specific factual analysis that we talked about just a minute ago. Again, the interactive process is mandatory, as I said above. It requires communication with the employee and a good faith exploration of possible accommodations. So you don't, like I said, you don't have to accept the employee's specific accommodation request, but you have to take good faith efforts to see if there is an accommodation that can be made that doesn't cause an undue burden within the company to provide to the employer, because an employer's failure to accommodate an employee's disability may result in a constructive discharge claim under the ADA, and then obviously subjecting the employer to liability. So anytime that there's a request for a reasonable accommodation or you believe there may be this request from an employer that has a disability, then you need to take this interactive process to determine whether or not an accommodation is available. One of the questions employers ask if an employee is requesting a leave of absence based upon the disability. The ADA doesn't speak to it, but the EEOC has said that you have to do that same undue hardship analysis on whether or not you can give leave. But you must grant the unpaid leave if there is no undue hardship. And in fact, you also must, in certain circumstances, provide for more than the 12-week unpaid leave that an employee would be entitled to under the FMLA leave if it's not an undue hardship within your organization. If an employee is on a leave as a result of a disability, you also, if there's an undue hardship that's in place, you also may fill that position. But you should be very cautious about doing that. Finally, if somebody says to you, I need a reasonable accommodation, you can't require the employee to do light duty work in order to have that be the accommodation. You have to actually come up with an accommodation that would allow the employee to do his job, his or her job, and not be affected by the disability. With regard to medical examinations of employees, the ADA sets limits on what you can and cannot ask or require of medical examinations. Pre-offer of employment, that you can't have any medical inquiries of any nature about the existence or severity of a disability prior to the conditional offer of employment. If you've provided a conditional offer of employment, you can make inquiries regarding medical examinations, inquiries and require medical examinations so long as those examinations are consistent, meaning that if you require a particular medical examination of one employee at a post-conditional offer, you have to do it with everybody. You can't just make the employee that potentially has a disability go through a medical examination. And you can withdraw a conditional offer, but only if that exclusion is job related and consistent with the business necessity. Once your employment begins, inquiries about medical conditions and examinations have to be consistent with your particular business. The ADA protects, I jumped ahead here. You can not hire an individual with a disability if he or she poses a direct threat to the health or safety of themselves or other employees. Risk of harm, it can't be speculative. It can't be based on stereotypes, but it has to be a real true risk of harm. And the determination should be made on an evaluation of the individual's ability to satisfy or perform the job in consideration of these four following factors: the duration of the risk to the health or safety, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of potential harm. As an example, we represent transit agencies, and the rules, the federal rules prohibit this as well. But if an individual who has a disability that causes seizure activity or diabetic issues, that's a non-speculative risk to individuals that if this person is behind the wheel operating for your company, and that would be a basis that a direct threat to health or safety could exclude an employee from a position and not be a violation of the ADA. Medical records under the ADA are obviously confidential, and the basic rule is that, but for limited exceptions, you must keep confidential information related to an applicant for employment. It should be made confidential, even if it contains no medical diagnosis or treatment. And if it's not generated by a healthcare professional. The specific example that we're using in this case is that an employee is making a request for a reasonable accommodation based upon a disability. That request would qualify as a medical record under the ADA and then be subject to the confidentiality requirements of the ADA. Finally, the accommodation does not need to be made for an employee for drug and alcohol abuse. If an employee is engaged in illegal use of drugs, that's not covered by the ADA. If you discipline an employee based upon the use of those substances. Tests under the for illegal drugs are not subject to the ADA's restrictions. Medical examinations, and you can hold employees or illegal drug users and alcoholics to the same performance standards as other employees. A lot of questions that I've gotten lately also request whether or not that also applies to marijuana. Ultimately, the American with Disabilities Act is a federal act, and marijuana is still illegal under the federal laws. So it wouldn't, I don't believe that it would make a difference in that circumstance. Again, I kind of blew through some of these slides in order to make sure that we have time for everybody. But if you have questions, please reach out to myself or anybody else within our team. And thanks for giving me the time.